Good afternoon, everyone. I'm sure there are a few more people joining us in the next few minutes. On behalf of Manila House, I'd like to welcome you to this webinar on libel and the law. I think that we're hosting today in partnership with Academiang Filipino. And libel has been in the news lately, mainly because of the controversial conviction of journalist and Rappler CEO Maria Ressa, and she was the first one to be convicted under the new cyber libel law. So we have our main speaker today is Attorney Geronimo Sy, a former Department of Justice Assistant Secretary and Bar Reviewer in criminal law. Joining us also to react to Attorney Sy's presentation are former Justice of the Supreme Court, Antonio Carpio, and award-winning journalist and co-founder of the news magazine Newsbreak and now Rappler editor-at-large, Marites Vitug. It's an honor to have our panel with us today, especially Justice Carpio. Thank you for helping us put this together with the help of Academiang Filipino, of which Justice Carpio is a member. Before I turn you over to Attorney Geronimo Sy, let me just give a brief introduction. Geronimo Sy is a former Assistant Secretary of the Department of Justice from 2008 to 2016. He established the Office for Cybercrime and Office for Competition. He was a member of the Supreme Court Committees on Criminal Procedure and E-Commerce. Prior to this, he was a state prosecutor handling specialized cases on money laundering, business fraud, cybercrime, terrorist financing, and cartels. Mr. Sy is a professor of law and bar reviewer and a lecturer in risk management and corporate governance. He is also an author and a columnist. He graduated with a Bachelor of Science major in Management Engineering and a Juris Doctor of Law from the Ateneo de Manila University. He also has a master's degree in public management from the University of the Philippines. And then I'll introduce you now to, well, Justice Carpio is our rock star justice, Supreme Court justice, who doesn't need any introduction, but by way of formality, let me just say that Justice Carpio is a retired justice of the Supreme Court of the Philippines. He served in the Supreme Court for 18 years from 2001 to 2019. He obtained his law degree from the College of Law of the University of the Philippines, where he graduated valedictorian and cum laude in 1975. He earned his undergraduate degree in economics from Ateneo de Manila University in 1970. Fresh out of law school, Justice Carpio went into private practice and founded the Carpio, Villaraza and Cruz law firm. He was a professorial lecturer of the UP College of Law from 1983 until 1992, when he was appointed Chief Presidential Legal Counsel with cabinet rank by then President Fidel Ramos. Justice Carpio was a member of the Board of Regents of the University of the Philippines from 1993 to 1998. For his distinguished and exemplary service to the Republic, Justice Carpio was awarded in 1998 the Presidential Medal of Merit by then President Fidel Ramos. In 2015, he was named an outstanding alumnus in public international law by the UP Alumni Association. That same year, the Department of Foreign Affairs sponsored Justice Carpio on a world lecture tour on the West Philippine Sea dispute. Justice Carpio presented the Philippines' perspective on the dispute before think tanks and universities in 30 cities covering 19 countries. In May 2017, Justice Carpio published the book entitled The South China Sea Dispute, Philippine Sovereign Rights and Jurisdiction in the West Philippine Sea. Justice Carpio was the chair of the second division of the Supreme Court and the chair of the Senate Electoral Tribunal. And Marites Vitug is a veteran journalist. She's our next reactor to Attorney Sy's presentation. She's been a journalist for more than 3 decades and is one of the Philippines' most accomplished journalists. A best-selling author, Marites has written 8 books on Philippine current affairs. Her latest book, Rock Solid, How the Philippines Won Its Maritime Dispute Against the China Sea, won the National Book Award in 2019. Marites has won other awards as well as public recognition for her reportage on justice, politics, government, and security. He's a former editor of Newsbreak, a pioneering political magazine which the New York Times described as having spunk and spice. Currently, she is editor-at-large of Rappler. And joining you today as moderator is myself, Bambina Olivares of Manila House. And I'd like to also extend a welcome to many of our Manila House members, of which include Justice Carpio and Marites Vitug as well. And hopefully Attorney C, you'll join us soon, right? Okay, thank you so much. And Attorney C, can we start with you? Shall I start your presentation?
Thank you, Ms. Bambina. There's actually not a major presentation. I just want to say that thank you for the invitation, and hello to Justice Carpio and this Ms. Vitug. Very good to see both of you in good health and in perfect isolation. I just want to clarify, is Ms. Vitug editor at large or she's at large? I couldn't hear it very well from the video. She's not at large, no? Ms. Marites, you're not at large, no?
No.
Okay, okay.
No.
But I just want to make this webinar with a series of lectures online that we're having. I want to make it feel like series one of a Netflix series. No, it shouldn't be something all hair merry. But I'd like to assure all our participants that after this webinar at 5 o'clock, should you receive a subpoena for attending this seminar, Justice Carpio and myself will represent you in court. Sama-sama na tayo, no? Just to make sure that you're free to ask questions. Now, in my introduction, if you can flash the slide, Ms. Bambina, quickly, I want to talk about your hairstyles today, your hairdos, because a lot of people are not on video camera. And I'm sure after 4 months of being in the lockdown, we have all adjusted our hairstyles so that we don't need to go to the barbershops and salons. I see Justice Carpio in his regular trim, all black hair. Ms. Vito, Ms. Bambina, your hair, everyone's all made up after 4 months. No? When we used to go to our salons and parlors monthly or every 2 weeks, now everyone has adjusted. This is the new normal. We cut our own hair, do our own nails, and do everything on our own. But the question is, we talk about new normal of activities in terms of eating out, restaurants, dine-in, online shopping, grocery. But the new normal for law, for courts, is still not in the forefront. And this is very natural in the development of law. Law is usually at the tail end of societal developments. No? Even if the nature of law is as a stabilizer, as a progressive tool to bring us human society from a lesser state to a better state, no? from a worse scenario to a better scenario. That has been the purpose of law through the centuries. And this is where I'd like to start in situating libel and cyber libel in the context of legal development. The new normal today is that social media is here to stay. And with that, a lot of problems, a host of situations that we have yet to fully grapple with. If you look at our law on libel, it is actually found in our main law, the Revised Penal Code, which took effect 1932, which I assume is older than any one of us here today. It's a 1932 law. And this 1932 law, if you trace its development, is actually an extension of the Spanish Código Penal of 1870. And this is where we get a lot of our provisions, including provisions on sedition. If you look at Title 13, Crimes Against Honor, that is where you find the crime of libel. Because in this early part of the 20th century, a person's honor, a person's reputation is seen as something removed, different from a person. This is also similar to the crime of rape as a crime against chastity. It's not a crime against a person, it's a crime against a person's chastity. This is under the old rape law. It took us until 1997 to recognize rape as a crime against a person, no? Instead of it being a crimes against chastity, as if a person and the chastity is different. Ms. Bambina, just a quick check. Maybe you can bring that up to a video, to the main talk.
Sure.
Right. Okay. I think that's better. Okay. So because that frames the discussion. If you look at Title 13 on libel, that is what we have today with all its complications. No? If you look at that, you trace it back to the 1870 Spanish Código Penal. The Código Penal of 1870 actually does not have a libel provision. What it has is a provision on calumny. I don't know which sounds more fearsome, libel or you're being charged with a calumny, no? But under the Spanish Penal Code, calumny was the malicious imputation that the person A committed a crime against B. That was it. It has to be a crime. In our revised penal code, however, this was removed. There's no more crime of calumny, but they used the crime of libel, which is, again, I want to repeat, not in the Spanish Código Penal. Now, where is the source of the libel provision, which a lot of people are stressing over these days? It actually comes from a 1901 legislation that traces it from the US. 1901, we're still a colony of the US, where we copied almost verbatim an Act number 277, and the framers of the revised penal code took out calumny and inserted libel almost word for word. And in that libel provisions, the penalty was prison correctional. This is under the revised penal code, which was also the penalty under the calumny provisions of the Spanish Código Penal. Prison correctional lang yung penalty, which actually reaches only up to 4 years. And of course, prescription limited to 1 year, whether it's calumny or libel. So that is the basic where we find the problem of this definitional problem of libel. You have a revised penal code that's from Spain, which is what we call continental system, but with a particular provision on libel from the Anglo-Saxon American rule. So you have in that particular title a combination of an Anglo-Saxon crime in the whole law that is of a continental regime. For lawyers, you will appreciate it more, but for lay people, you just think of it as a hybrid, no? A car that runs both on gasoline and diesel. You're trying to make it run efficiently. So that is where we're at today. So this libel, if you read it, whether lawyers or not, now we're on the same page. In a matter of 6-7 provisions, it can actually dramatically change your life, because it's a very complicated provision that will actually fill a couple of volumes of annotation. If you go through it, it's very, very complicated. What is the reason why this libel in our present revised penal code is so complicated? It is complicated for 2 simple reasons. When the Spanish Código Penal of 1870 came into place, this was at the height of the codification of penal laws. Before the 18th, 19th century, penal laws were not in writing. It was based on the king's command. But starting 18th, 19th century, people started writing the German Penal Code, the French Penal Code, the Spanish Penal Code, which found its way to the Philippines in the revised Penal Code. And at the 18th, 19th century, this was at the height of the technical refinement of the codification. The writers were trying to capture good and evil, right and wrong, in a very, very refined way, trying to fine-tune it, trying to put as much details to get it to perfection. This is where it was in 1870 and then to 1932. So if we see our revised penal code, it's a tough read because it's at a period of technical refinements. And note, the 1870 Penal Code and the subsequent 1928 Spanish Penal Codes have already been abolished even by Spain. And yet in the Philippines, we're still trapped in the very old provisions which we base our revised penal code on. So that is where the complication is. The provisions on libel, and this is what makes it difficult, is what we call the burden of proof. In the present libel, you have what you call the burden of proving the truth. So, for example, Ms. Marites, if you don't mind making an example, if A charges you with libel against Ms. Marites Vitug, Ms. Vitug has the burden of proving that what she wrote is true. So it's just not a matter of burden of proof, it is about the burden of truth. In the old days, it was even worse, because the greater the truth, the greater the libel. That was even the older conception before 1870. So now the rule is the burden of truth is with the journalist or with the writer, which sounds funny in our tradition because we're used to the idea of burden of proof is on the part of the one charging the responded. No, that is one aspect. And even if what you say is true, which is what we call the proof of truth, it's not enough. You have to prove that you did it with good motives and justifiable ends. This particular phraseology, proof of truth with justifiable motives and good ends, is actually from Alexander Hamilton in 1805. It's called the Hamiltonian Rule, which says the proof of truth is allowable if you meet those two requirements, good motives and justifiable ends. This rule, unfortunately, for the past 200 years, is no longer used anywhere in the States. This is the narrow rule of the Hamiltonian concept. Now, in some jurisdictions, proof of truth is an absolute defense. You don't need to prove any other things. No? But we were caught at that period where we wrote into our law the Hamiltonian concept of the narrow defense of truth plus other requirements. So that is where we are at now. The next development, which is significant, is 1964, when the US Supreme Court said that any form of libel is no longer criminally possible because it's now covered under the First Amendment, freedom of speech, we are familiar with. So criminal libel in the States has been removed and it's been moved to civil libel, which means you can be filed civil cases for tort or damages. However, in the Philippines, criminal libel still is with us in the 21st century. So that is the long history of libel that I've tried to capture in 10 minutes. No? It gives you the complexity of why Articles 353 and the following are very difficult to read, why it's difficult to mount a defense, why the particular burden of the respondent in trying to discharge libel. Libel per se is not a bad idea because we also have a right to be protected in our reputation. But the approach, whether you want it criminally responsible, or the criminal liability, is something that can be addressed on a separate mode. Now, fast forward to 2008. When we started writing the Cybercrime Prevention Act, we were very conscious that the Cybercrime Prevention Act should only focus on what we call the genuine core cybercrime cases. What are these cases? Phishing, spam, fraud. No? These are what we have today. Is it a good law? I'm biased, but I think it's good law because without the Cybercrime Prevention Act of 2012, in 2020, when we're facing all this increase in cybercrimes, we would not have a law in place to protect us against all these cybercrimes. So it's a good law. But what happened? Senator Soto inserted this provision of the cyber libel into it, simply because at that time, he was being pilloried in media for a lot of things. No? So he inserted that at the last minute in the BICAM, in the plenary, in just those periods, which when I was the chair of the committee of the Department of Justice, we objected and said, can we not dilute the law or change the law because it has a lot of ramifications? But of course, senators, the way they are, they wanted insertion, it was inserted. And this is not something that only happened once. In the Bayanihan Act of this year, Section 6F, you already have another provision, again inserted by Senator Soto, on the fake news. No? So if we're up to him, he would actually put all of these cyber libel, false information, criminal cases in a lot of these laws. No? And that time, when we argued against it, we said, if really we cannot stop you from putting it, can you just give us at least a few days to clean it up, to study its impact on prescription, on penalty? No? Just give us a few days to come up with the language if you really want to put it there, to harmonize that with libel. But we never got the chance. So from 2012, challenge in the Supreme Court, all the way to 2020, all this haka-haka, all this uncertainty, the purpose of law as a stabilizing factor, as a tool for progression, is actually becomes an issue of dissension, of confusion, of unstable processes and practice. No? When we ask for a few days, even just a day, to clean up the language. No? So that is how cyber libel came into the law. But our position has always been consistent everywhere, that it's not necessary, it totally can be deleted, and it's not a cybercrime. Cyber libel is not the cybercrime as you would experience it anywhere in the world. Cyber libel is just libel committed in a different form. No, again, but that is something that is past. 2012 moving forward, we've actually put amendments to the Cybercrime Prevention Act. Simply because if we change our cell phones once a year and we don't change our cybercrime law every 5 or 10 years, increasingly our cybercrime legislation will be obsolete. No? So we have to keep on passing this. And all these amendments will actually take away libel and all its attendant problems. So that is how cyber libel can be traced. And in the 21st century, in 2020, when you have a conviction of Maria Ressa, suddenly you have talked about the publication, republication. You are still trapped in that concept of a traditional crime, not in the new normal thinking. Because the new normal thinking of libelous article is actually a part of the right to be forgotten. In Europe, if somebody says things against you, or even if it's true, but you get a judgment to say you have the right to be forgotten, the one who posts that has the obligation and duty under pain of penalty to remove and scrub all the mentions against you. So in the Philippines, we don't have that. Once an article, libelous or not, is published, it stays there. It's very difficult to remove it. So this conception of publication, published once, twice, several, is not paripasu with what is the 21st century conception of publication. No? So this is one very clear. And in the Maria Ressa case, where I would like to mention this, is the problem of updating the article. No, because they updated actually just one spelling error, the spelling of tax evasion from S and T. The particular problem with republication is this. Every time we repost, every time you update the article that is archived actually zooms up and becomes headline again. That is a particular problem with reposting republication. What we see in the practice now is when you update it, the writers will say updated for error, updated for new content, updated as of this. You see that particular changes. So if it's a mere formal change, then you don't have to worry about it being a republication. But if it's substantive change, then probably it is a republication. And what we are in 21st century again is we've traced libel. We've seen cyber libel. It's not a new law. It's not a new crime. It's just Cybercrime Prevention Act with a provision. Then you go into now is what is our response as individuals, as concerned citizens, as journalists, as lawyers. The first response is we should always just craft a better libel provision, put all of this together into a 3 to 5 page law, decide whether it should be a civil libel, a criminal libel, or there should be a self-regulatory status for journalists to say 3 strikes and you're out, first strike, suspended license, or a similar quote-unquote combination of such penalties. No? In an informal survey of lawyers conducted about 6-7 years ago, people in a vast majority still think libel should be punished. But whether or not it's criminally punishable is a different discussion that we ought to have. On a personal level, if you're posting all of these social media, you also have to be careful that it's libel is out there. Cyber libel is a specter. Then you have the problem of fake news that is also criminally punishable. And if you don't have the particular need for it, if you're just a gadfly wanting to comment, just make sure that there's a couple of do's and don'ts that you want to follow. Free speech, we will always have it. We'll always fight for it. But there are smarter ways to go about it so that you don't actually have to expose yourself to a subpoena from the NBI simply because you wrote something against a government official. I'd like to end this short talk with a rule on government officials. In the history of libel, it's a very clear carve-out that fair criticism on government officials, on public figures, is actually privileged. No? You don't have to worry about that as much as you would be in attacking a private person. And there is a difference between major government officials, let's say a senator and a president, versus quote-unquote, let's say a ordinary bureaucrat. The higher you go in the hierarchy of government, quote-unquote, the more you should be able to take criticisms of different sorts. No? And I say this in the context of the recent reports that Senator Bongo has actually, quote-unquote, filed several quote-unquote libel cases against this. And I think all of these cases would fall squarely under the concept of fair criticism of government officials. So I hope that puts it in context in the situation of libel, cyber libel, a quick look at 18th to 21st century development and its history, particularly in the Philippines, of which I had an inside knowledge of how it worked and how it came to be. And the problem is actually with our legislators who do not have the intellectual humility to say, wait, I don't know about this. Can we ask somebody? If you look at the scan of both houses, Senate and House, can you think of a legislator who as legislator is an expert legislator? None. Our both houses are pathways to politicians, no? And even if that is the democratic way that we have, you should still have that intellectual humility to say, I'm here as a politician, I may have political skills, but I don't have the subject matter competency of a journalist, of a lawyer, of a doctor, of an educator. Can we at least look at it something before it impacts 110 million Filipinos? But this is not surprising because many of our legislators also do not have the moral humility. If you make a mistake, you want to apologize, you cannot even apologize sincerely, blanketly. When you apologize, you have to blame somebody, you have to justify your actions. And this is actually the problem we are faced. Legislators are not held to account for inserting provisions, bad provisions in good laws. We don't have a lot of laws, we have a lot of bad laws passed by bad legislatures. So I hope that rounds up the discussion, and I'd like to turn over the floor to Ms. Bambina. Thank you.
Thank you, Attorney Sy, for that very comprehensive overview of libel throughout the centuries and how it's actually relevant to us today in the new form of cyberspace that we all are clued into, are connected in, especially at this moment. Before I turn you over to Justice Carpio for his reaction, I would just like to remind everyone, if you have any questions, you can actually put them in the Q&A box and type them in, and we'll address your questions after. Thank you. Justice Carpio?
Thank you, Bambina. I just have 2 points to bring up, considering the historical background that was given to attorney. My first point is on the prescriptive period of cyber libel. In the Rappler case, the RTC ruled that the prescriptive period is 12 years, applying Act number 3326 on the ground that cyber libel, on the ground that under the Cybercrime Prevention Act of 2012, that this law is a special law which does not provide for its own prescriptive period. And Act number 3326 governs the prescriptive periods of special laws that do not provide for their own prescriptive periods. So the RTC applied Act number 3326. However, in the only case so far that we have decided by the Supreme Court on cyber libel, the Cine versus Executive Secretary, the Supreme Court ruled that, and I quote, cyber libel is actually not a new crime, close quote. In resolving the motion for reconsideration, the court reiterated cyber libel, and I quote the court now, is essentially the old crime of libel found in the 1932 revised penal code and transposed to operate in the cyberspace, end of quote. The court explained that under Article 355 of the revised penal code, libel can be committed by means of writing, printing, engraving, radio, etc. And there is this catch-all phrase, or any similar means. The court stated that cyber libel, which is libel committed with the use of a computer system or the internet, is a similar means of committing libel. So the traditional libel is print libel, radio, TV libel. And libel with the use of a computer or through the internet is a similar means. So it will fall under the same article of the revised penal code. So cyber libel is a crime defined and penalized in the revised penal code. The revised penal code has its own prescriptive periods. Article 90 of the revised penal code provides the prescriptive period of libel or other similar offenses. So the phrase says libel or other similar offenses. The prescriptive period is 1 year. So under Article 355 of the revised penal code, cyber libel is a similar means of committing libel like traditional radio libel. Moreover, under Article 90 of the revised penal code, cyber libel is also a similar offense as traditional libel for purpose of the 1 year prescriptive period. So we have two provisions of the revised penal code reinforcing each other that cyber libel is a similar means of committing traditional libel and has a prescriptive period of 1 year since it is a similar offense to traditional libel. So it's very clear, cyber libel is a crime defined and penalized in the revised penal code. And the revised penal code says prescriptive period is 1 year. Under the Cybercrime Prevention Act, cyber libel is penalized by imprisonment of 1 degree higher than the traditional libel of print or radio libel. This really means that libel committed with the use of a computer system or the internet is merely a qualifying circumstance that increases the penalty for libel by 1 degree, but this is not a new crime. It's the same crime as stated in the revised penal code. The fact that you use a computer or the internet merely increases the penalty of libel. Now, the degree or length of penalty for libel has nothing to do with the prescriptive period for libel. Before 1966, the prescriptive period for libel was 2 years, but this was reduced to 1 year in Act 4661. But the penalty remained the same. The length of the penalty remained the same, but the prescriptive period was reduced. So the penalty has nothing to do with the prescriptive period. Now, in cyber libel, you have a penalty higher by 1 degree, but that higher penalty does not affect the prescriptive period because there is no correlation between the penalty for libel and the prescriptive period. In Article 90 of the revised penal code, where you find the prescriptive periods for crimes, there are 2 classifications. One classification are for crimes where the prescriptive period depends on the length or severity of the penalty. But there's another category where the prescriptive period depends on the nature of the crime, regardless of the length of the penalty. And libel falls in that category. The prescriptive period for libel is 1 year, but the penalty is considered correctional, prison correctional, and the prescriptive period for prison correctional maximum, the prescriptive period is 10 years based on the maximum penalty of prison correctional. Now, under Article 90 of the revised penal code, correctional penalties like the penalty for libel, the prescriptive period is 10 years, but the law says no. For libel, it's different. It is only 1 year. So there is no correlation. So whether you increase the penalty for libel under cybercrime by 1 degree higher, it doesn't change the prescriptive period because the prescriptive period for libel does not depend on the length or severity of the penalty. Furthermore, Section 3 of Act number 3326, the law that the RTC applied, Section 3 expressly states, and I quote, "For purposes of this Act, special acts shall be acts defining and penalizing violations of the law not included in the penal code." In short, the very law that the RTC in the Rappler case used as basis for the 12-year prescriptive period itself provides that the law, Act number 3326, cannot apply to crimes penalized in the penal code, which we now call the revised penal code. Clearly, the 12-year prescriptive period in Act number 3326 cannot apply to cyber libel because Act number 3326 expressly so provides. So Section 5 of Act number 3326 expressly directs the prosecutor and judge do not apply Act number 3326 if the crime charge is defined and penalized in the revised penal code. That's very clear. You cannot apply the prescriptive period of 12 years for crimes defined and penalized in the revised penal code. And cyber libel is defined and penalized in the revised penal code. Lastly, during the oral arguments in the Supreme Court on the constitutionality of the Cyber Crime Prevention Act, the Solicitor General, the principal lawyer of the government, manifested before the court and bank as follows, and I will quote the Solicitor General speaking now to the Supreme Court during the oral arguments. He said, "We finally add, Your Honors, the prescriptive period for the crime of libel remains to be 1 year under the Republic Act 4661, despite the Cyber Crime Prevention Act, Republic Act 10175. So the government lawyer told us when we were there in the Supreme Court during the oral argument, the prescriptive period for cyber libel is still 1 year. That's the position of the government, official position of the government. Now, my second point is the liability of publishers and editors for what viewers write or comment in online newspapers or platforms. Let us discuss online newspapers. Viewers make comments right after the article, right after a column. And if viewers make libelous comments on the news article, or the news report, or event in an online newspaper, that is cyber libel, because those comments are not share or like, but actually assertions of or commentary of facts or events that are reported in online papers, because under the Cyber Crime Prevention Act, retweets or share or like are not punishable. Only the author will be liable. But if you make a comment after a column or an article, that is not a share or like. You make your own comment. The viewer makes his own comment. And if it's libelous, that's cyber libel. Now, if viewers make libelous comments, who will be liable? Of course, the viewer and the editor and publisher of the online newspaper will be liable. But what if the viewer is anonymous? Many viewers do not give the real name, and online newspapers do not require any verification as to the identity of the viewer. Many viewers are from China, and they use Filipino names that are obviously fake. These viewers from China with fake identities are also called trolls. In case of anonymous viewers, who will be liable? Only the editor and publisher, because nobody can find the anonymous viewer. You don't know the person. You can find his address. But there is more to this. In libel or cyber libel of a public figure, Atty. Sy was referring to this earlier, the burden of proving actual malice is on the person libeled. The public official or public figure who is libeled. The burden of proving actual malice is the person libeled if it is a private individual. But there is no presumption of malice in a libel of a public figure, as there is a presumption of malice in a libel of a private person. So if it's a private person, the person libeled will have to prove, the journalist will have to prove that there is a justification of what Atty. Sy says, good intention and justifiable reason if it is true. Now, but if it is a public figure, the burden of proof is on the person libeled. He must prove actual malice. So if the viewer who makes the libelous comment is a fake person, and the online newspaper did not verify the identity of the viewer, but simply allowed him to post comments that are libelous, what are the consequences? The person who wrote the comment is unknown, he's anonymous. What will be the consequence on the editor and on the publisher? I think the online newspaper, if it does not situate or does not verify the identity of the viewer, then that is evidence of gross negligence by the newspaper in ascertaining whether the assertion of the viewer is false or not. So if the editor and the publisher just allows anybody to make a comment and that person who made the comment turns out to be fake, nobody can locate that person, then I think there's gross negligence on the part of the editor and the publisher. There is obvious recklessness on the part of the editor and publisher of the online newspaper in allowing any Tom, Dick, and Harry to post comments in their newspapers without verifying whether these people are real or fictitious. Real people will be more circumspect in posting comments because they know that they can be sued. But the people who use fictitious names think their real identities cannot be discovered. And so they make libelous comments without fear of being held to account. Thus, I think if the online editor and publisher do not verify the identity of people who make online comments, then they can be held as grossly negligent for purposes of determining actual malice. How can editors and publishers verify the identity of a person who wants to make comments in their online newspaper? Well, they can require that person to submit online 1 or 2 identification cards, like the driver's license, voter's ID, student ID, employment ID, senior citizen's ID, or passport. Documents that can be used to verify the identity of the person, that he is the person he claims to be. And the editor and the publisher must also secure the email address and the telephone number of the viewer. Such a requirement will, I believe, establish that the editors and publishers were not grossly negligent in allowing those comments in newspapers. For one, the editors and publishers can contact the viewer for verification of the accuracy of his comment or give the contact address of the viewer if the person libeled wants a clarification or apology from the viewer who made the comment. This is fair and reasonable requirement on online newspapers. In the US, under Section 320 of the Decency Communications Act, the online platforms like Facebook and YouTube are not treated as publishers or speakers. They are exempt. All those who comments, you have to register, they are not considered publishers or speakers. So if a viewer makes a libelous comment, YouTube or Facebook cannot be sued in the US because they have a safe harbor under Section 320 of the Decency Communications Act. But this unique law is not applicable in the Philippines. So in the Philippines, Facebook and YouTube will be legally treated as publishers for purposes of the cyber libel law. But so far, nobody has tested it. So I will end my brief remarks here. Thank you.
Thank you so much, Justice Carpio. There was also another comprehensive overview of the law and how it applies to different media of different social platforms, especially. Now we're going to turn to Marites Vitug, who's had quite a few libel cases in her day. So she's going to talk from the point of view of a journalist. Thank you.
Hi, good afternoon. And as Bambina said, I'm the only journalist in this panel. So I'll be speaking about my experiences with libel cases under 3 presidents, Cory Aquino, Gloria Arroyo, and Benigno Aquino III, or Pinoy. I'm mentioning this to give a context and to show how the political climate during those years is different from today. So 2 libel cases were filed against me during Cory Aquino's presidency. The first was in 1988 when the relative, Margarita Tingting Juanco, took me to court. This case reached the Court of Appeals and then the Supreme Court, which decided it in 1994, fortunately in my favor. The second was in 1989 when a wealthy businessman, Jose Pepito Alvarez, currently governor of Palawan, slapped me with a 26 million peso libel suit. At the time, it was the most expensive libel suit ever filed. Apparently, Alvarez eventually lost interest in the case because we never reached trial phase. There seemed to be no pressure. It was under President Arroyo when I had the most number of libel cases. First, because as editor-in-chief of a magazine, Newsbreak, I was always included as a respondent. And second, Arroyo was president for 9 years, much longer than the usual 6 years. So among those who sued us at Newsbreak were, drum roll, First Gentleman Mike Arroyo, Senator Juan Ponce Enrile, Senator Robert Barbers, Ilocos Sur Governor Chavit Singson. Mike Arroyo had a change of heart, remember had done heart surgery, and decided to drop the case. The cases with Enrile and Barbers went through mediation and were resolved. This is very interesting. Here was part of the deal with Senator Enrile. His lawyer said we were to give him a lifetime subscription to Newsbreak magazine. But guess whose life was snuffed out first? Newsbreak lost its printed edition many years ago, and as we all know, Senator Enrile is still very much alive. The case filed by Singson was dismissed by a brave Ilocos Sur judge only after Singson was no longer the governor. And during the last months of Arroyo's presidency, a Supreme Court justice, whom Justice Carpio knows quite well, Presbitero Velasco, sued me for libel over a book I wrote on the Supreme Court. So not content with one libel case, he sued me again during the early years of Pinoy's presidency because the article, an article which was excerpted from the book was published online. Then a sitting justice, Velasco, eventually withdrew the libel cases, and he's now governor of Marinduque. Maybe times were simpler then, and these were all before the passage of the Cybercrime Prevention Act of 2012. But I just like to say that many journalists take libel cases seriously. In my experience, I found these cases to be a form of harassment. They were meant to send a message that journalists should refrain from writing critically about these persons and public figures. So if there's one lesson I learned through all these cases, it was to stand on solid ground by verifying information and double checking the facts, getting the side of the person written about. As we know, there are more than 2 sides to a story, and there's context, which is very important. So today, under President Duterte, the political climate has changed. Having people investigated for their social media posts seems to be a weapon of choice to intimidate people. Same with the filing of cyber libel cases. Just a few examples. The journalists, it's not simply journalists who are affected by this. In April, the NBI, using an old law, the revised penal code, particularly Article 154, summoned more than a dozen netizens for their posts on social media because this provision punishes the publication of any false news which may endanger the public order or cause damage to the interests of the state. In addition to this, Justice Secretary Menardo Guevara in February this year issued an order authorizing the NBI to investigate, quotes, alleged deliberate spread of misinformation and fake news on the coronavirus. But here's the irony. No less than Duterte and his Health Secretary Duque have made false claims on the coronavirus. And then remember 2 high-profile cases, the arrest of a Cebu artist and the threat to have a Filipino overseas worker in Taiwan deported. Bambi Beltran, a film writer in Cebu, was arrested without warrant after her satirical post on Facebook. In the case of the OFW, the Department of Labor asked Taiwan to deport a Filipina caregiver working there for her supposed attempts on social media to, in quotes, discredit and malign President Duterte. Thankfully, Taiwan upheld the workers' right to free speech and rejected the Labor Department's request. And of course, as Atty. Sy and Justice Carpio talked about extensively earlier, the Rappler case. And again, the most recent buzz, as Atty. Sy mentioned, is from Senator Bongo. He wrote the NBI asking them to investigate about six netizens for their post critical of the senator. The NBI sent subpoenas to them without identifying who the complainant is and what the social media post is all about. So these were all blind summonses. As Justice Carpio said, the Supreme Court has ruled that sharing a social media post does not constitute cyber libel. So just to end my remarks, a libel suit, as it is a criminal offense in the Philippines, is really a burden on the journalist, on one's time, finances, paying bail, lawyers' fees, unless they're pro bono, and also disrupts our equanimity and causes sleepless nights. So it's not easy. It is not something journalists welcome. And add to this, the overall climate of fear under this government, then we end up with a double whammy. So thank you.
Thank you so much, Marites, for that, the journalist point of view. Before I open, I'll open these. We have a couple of questions here in the chat box. I just wanted to ask Atty. Sy and maybe Justice Carpio as well. You know, you mentioned something, Atty. Sy, that was, I think, very important. How you said our legislators seem to display no capacity for intellectual humility nor for moral humility. Now, perhaps there are a couple of people here, or more than a couple, would agree with that statement. Why is that also the reason why libel has not been decriminalized? Why it's not a civil suit? There every couple of years there's a clamor to decriminalize libel, and I guess like divorce, it gets shot down by the Senate or the lawmakers. I think you just have to mute, Atty. Sy. You have to mute your mic. Let me yeah.
Okay.
Can I unmute you? Yeah.
Thank you, Justice Carpio and Ms. Marites, for your reaction. I think they round up our discussion from different perspectives. I was just wondering why Ms. Marites, under this administration, has 0 libel cases. Wala pa ba? I hope you're not waiting for the cases to come. But on that quick question, to provide the context, the increase in 1 degree in the Cybercrime Prevention Act, the design of that particular provision was on the aspect of, to take for example, threats. If I issue a threat in person, A against B, that's a physical threat under revised penal code. If I issue a cyber threat posting on Facebook, I will rape you, I will kill you, the magnitude, the danger of that particular cyber threat is of a different quality, because suddenly your threat is now in social media. And that is why that particular provision was put there to cover for all these cases. Of course, you cannot have cyber rape. No? You cannot rape someone. You cannot have sexual violence online. But other species of abuse in the revised penal code, chiefly threats and similar aspects, are precisely within that concept. So that was a technically complete law from that. But as I said earlier, if you insert a cybercrime, a cyber libel into it, then suddenly it's like you have a blueprint for a house. Suddenly you want to add a room, you want to add a bathroom without regard to the drainage and plumbing. That is what exactly what happened. So that is the context of this particular provision. And I agree, this libel never got studied the way it should have been studied. And it's really unfortunate that libel has been described always as a quagmire in different jurisdictions. No? In the Philippines, we do not seem to have the capacity to come up with decent, good laws. The concept of practical law passage is not there. What the legislators can do is what we call piecemeal legislation. a law punishing camcording, a law punishing child pornography. Very, very quote-unquote narrow formulation of law. In fact, if you read the penal provisions of Section 6 by Act, and if I may say so, with all professional humility, they're amateurish, no? Very amateurish in the formulation and the writing. If you're a journalist, you should have a basic command of grammar and English. If you're a lawyer, know your law. If you're a doctor, know anatomy and the related medical applications. If you're a legislator, at least you have to have certain competency writing this. Just look at Section 6, look at the laws that we have passed in the past 10 years. Mediocrity. There's no standard of excellence. There's no feedback. No? The more you pass the laws, the more bills you have, the more you get elected. There's no question on, is it a good law? Does it meet the standard of excellence that befits the Filipino people? There's no discussion like that. So what is happening is you raise to the minimum, you pass populist laws. Laws are popular, people used to pass, no need for Magna Carta, no need for deep analysis or thinking. You just pass it and be proud to claim it as the author of such a law. So that is that particular context. And I also agree with Ms. Marites, it's never fun to be at the receiving end of a subpoena, rightly or wrongly. And if ever you do receive a subpoena without appropriate details, if you go legal, and you should go legal, don't go without a lawyer, you can be arrested simply for showing up in the NBI abuse of a warrantless arrest provision. No need to face that kind of risk. Get a lawyer, not just any lawyer, don't get a corporate lawyer, a labor lawyer, which is a problem of a lot of our netizens there. Ay, pare-parehas lang yung abogado, get somebody actually knows criminal law. And be smart about it. And I always say, precisely with the problems of social media, bobo na lang kung malalibel ka if you're charged for libel. There's 100 ways that you can be malicious, be vengeful in the way you attack without being attributed to you. That's the problem of trolls, that's the problem of false news. So if you really want to do it the right way. The last point is, I think everybody has shopped on Lazada. Lazada says it's a beautiful mug, silver, it will hold heat for 12 hours. When you get it, it doesn't even hold for 2 minutes. No? So you go against the seller, you also report to Lazada. Is Lazada liable for this particular problem of a defective good or a good that does not meet the promise of what it is? Is Amazon liable for selling fake LV bags? That is the discussion that is still very, very unclear in the present e-commerce today. And this is also the problem with online comments that Justice Carpio was speaking about. If you post online comments as a reaction to a column which are libelous, to what extent is liability attributable? Is it similar to the platform of an Amazon or a Lazada that provides the payment channel? That is the discussion that we have in the 21st century.
Attorney C, how can we move towards decriminalization though? I mean, it's not going to happen with the kind of legislators we have at the moment, because for them it's a tool, it's a power weapon.
It's
keep like journalists in place and dissent kind of, keep it down.
I agree with the punishment of libel, because we also want to quote unquote put guardrails on the concept of free speech. No? So it should not be the problem of a person defending yourself, especially in social platforms. I think the best way to do it is to come up with just a separate law, cut it out from the revised penal code, cut it out from the cybercrime prevention code. 3 to 5 pages of a well-written provision on libel that protects public officials and citizens, private alike, but providing very good defenses, not the narrow Hamiltonian rule of proof of truth plus other conditions, but say proof of truth. Then, very curiously, our revised penal code provision on libel is probably the only few remaining provisions that even protects the reputation of the dead. No? Blacken the reputation of the dead. So even the dead, somebody can actually file a libel case invoking the reputation of a dead person. So a lot of these provisions, and you see it in all our revised penal code, in all our 1900 legislation up to the present, and it's been happening. And it causes a lot of consternation if the state is against you, or if just a bad family member coming against you, you can invoke 101 laws that have not been cleaned up. You have a lot of junk files in our criminal justice system.
Thank you. Now let's go to the questions. We have quite a number of questions here from our audience. A lot of it concerned with social media and the ramifications. So just it might be a little repetitive, but maybe it's a good idea to bring it up again. So if you post an online comment on a political view that constitutes one freedom of expression, is that libelous? What is the boundary of expressing one's views, and up to when can we exercise our freedom to express our views?
Justice Carpio or Ms. Marites, would you take first crack at that?
Okay, the rule is still that for speech to be penalized by imprisonment or by fine, there must be a clear and present danger of evil that the state has a right to remove. And the ruling there is that the speech must invite imminent unlawful action from the audience. That's when the speech can be curtailed. Now, the bar is very high, to curtail freedom of speech. And in case of libel, that's when the person libeled is a private individual. Of course, there's a presumption of malice, and it's harder now to, the burden is on the speaker, the person who is being sued. But the court has established a very high bar before freedom of speech can be curtailed. And all these cases will eventually reach the Supreme Court, and that high bar will be applied. So this threats now to arrest people, journalists, because of libelous or seditious articles. The journalists must just fight and bring the case to the Supreme Court, because in the Supreme Court, we have this rule. There's a very high bar to curtail freedom of expression.
Just to add to that, Ms. Bambina, is the concerns of netizens now is if you are a private person, you post on FB against another private person. That's the usual away. And I'd like to give this in the context. If it's a person A says PI mo to person B, post that online. Per se, that is not automatically libelous. No? You actually don't mean that B is the son or daughter of a bitch. So that's not per se liable. Libel has a certain requirement of publicity, which is easily met in social media, because once you post it, the requirement of publicity is met. But there is also the requirement of a malicious imputation, which is actually more of a legal requirement. So if you say something, it's attendant with malice that will cause discredit and dishonor, but that particular imputation has to be an imputation of a crime, a vice, or defect, which is actually very broad. And that is why netizens, by and large, would actually just look for two more elements. What is the content of what you're saying, and what is the effect on that person to whom you say it to? If those two other requirements are met, since publicity is actually embedded into social media posts, then a libel case can actually be filed against the one who posts a particular statement.
Okay, but someone has a question here about asking for a little bit more of an explanation why the burden of proof is on the accused and not on the accuser himself or herself.
It's actually a colloquial expression, no? Meaning it's not actually evidentiary rule. But if you are the respondent, say Ms. Vitug, you're charged with libel. You want to say, totoo naman yung sinulat ko eh. Totoo naman yung sinabi ko eh. No? You have to show that it's true. It's actually true what you wrote. That is the burden of truth that we just described. There's no shifting of the burden of proof based on criminal law. The person libeled still has to prove the elements of libel: publicity, malicious imputation, the effect of that particular statement. But for the respondent, let's say the journalist, she has to prove that what I wrote is true, burden of truth. Not only burden of truth, but you have to have the other two more requirements. You did it for good intentions and for justifiable purpose. So naging mahirap yung burden of proof ng journalista. But of course, they also have the problem of specters of journalists that are fake journalists. No? The problem of black timers. No? Anyone can claim to be a journalist simply because you have a social media post, you're a blogger. Somebody will always claim that you're a journalist. But whether or not you're a journalist is something that is not just based on a mere claim that you are a journalist. And that's where the rules of libel will have to apply in terms of the burden of proof as a burden of truth.
In terms of journalism and different publications, what about a satirical piece? How is that affected by libel when it's clearly satire?
There's always a saying from a lot of novelists, no? Politicians do not understand satire. They're the last people who will pick it as satirical. But I am of the professional opinion that satire should not in any way be considered as libel. In fact, that's a higher form of speech that should actually be in freedom of speech. But in the era of populist government, you satire at your own risk. That I think is the prevailing mantra now.
Well, that also takes a certain amount of intelligence, right? To understand that you're the target of satire, I suppose. The target of satire, you get a free pass somehow, hopefully. But this is a question for, another question for you, Attorney Sy, since you set up the cyber crime office. Cyber libel is one of the top three types of cases that take up the time of the PNP Anti-Cybercrime Group and the NBI Office of Cybercrime. Does it not take away from precious resources for more important cyber cases like hacking, financial crime, and child porn?
That's a very good question, Ms. Bambina, because it becomes a policy departmental thrust, no? Because it does take away. In fact, if you look at our court system, 70 to 80% of our court system are composed of two types of cases: bouncing check law and drug cases. Can you imagine a whole legal infrastructure just addressing collection and addressing a public health issue that is a drug problem? And if you look at the cybercrime, which is a very technical, very difficult law that requires global cooperation, requires very fast and competent investigators, like the Wirecard controversies, phishing scams, the ones that are really hurtful to citizens. Now we have NBI and PNP led on a wild goose chase to act on every complaint on libel, especially if the patron is a very important public figure. And that pushes away all these resources from where they should be focused on: the real protection of our internet infrastructure, for commerce to flow, for free speech to flourish, for governance and transparency to happen. And unfortunately, that's what's happening. It should take a very strong policy statement to say, libel is not priority. I mean, at the end of the day, there's so many ways you can go around libel in the social media age.
Thank you, Attorney Sy. A question from Anthony Bengzon for the Manila RTC Branch 46 ruled that libel committed online prescribes in 12 years from publication, republication instead of 1 year. As a jurist, if you were to give the judge and reason, what grade would you give? I'm assuming this is the case of Maria Ressa. This is her branch. This is the RTC branch, right? Would you care to comment?
Yeah, well, I've already said that the prescriptive period for cyber libel is only 1 year. It's not 12 years as the judge ruled. So that case should be dismissed because it has already prescribed. And I've explained it also now. That is my position. There's another point I want to bring because the criminalization of libel has been brought up. The Office of the Court Administrator of the Supreme Court has issued guidance to judges that in case of libels, if they find somebody guilty of libel, they should impose a fine and not an imprisonment, because the law says imprisonment or fine. And the recommendation of the Office of the Court Administrator is to impose only a fine. But of course, it's up to the judge at the end of the day. So there is a preference by the court administrator, and of course, that's under the Supreme Court, that in libel, the penalty should be a fine. The recommended penalty is a fine. And this sends a message, I think, to Congress that it's about time to review the decriminalization of libel, because the courts now don't want to impose imprisonment. Unfortunately, the RTC of Manila in this Rappler case imposed imprisonment, contrary to the guidance given by the court administrator. But you can see a trend that we don't want to imprison people. The courts are saying we don't want to send people to jail for libel. They will be punished by a fine. And I think there should be lobby for Congress to amend the law to decriminalize libel and make it a pecuniary penalty. Thank you.
Actually, this decriminalization of libel towards a civil libel system is also good for the complainant, because a lot of people forget that if you go for criminal libel, the standard of proof is proof beyond reasonable doubt. It requires at least 85 to 90%, no? If you mathematically convert that. But if you go for civil liability, then the evidentiary requirement is actually preponderance of evidence. For a layman's term, it's just 51%. No? So that makes it easier if you want to complain on libel. That's also one argument for decriminalizing libel and moving it towards a civil regime.
Corollary to that, I have a question from Don Di Mapa. If libel is only penalized by a fine, then what's to prevent a wealthy owner of a publication who can presumably afford to pay multiple fines from repeatedly committing libel? I just off the top of my head, that is a journalistic integrity issue, right? I mean, because no publication, I would imagine, would like to have irresponsible journalists on their payroll making libelous claims. So that's just, but Attorney C, I'm sure
In law, there's a concept called sentencing guidelines. We don't have that in our civil law regime in the Philippines. But the sentencing guidelines is like this. If you're a journalist, you get convicted the first time, fine. The second time, bigger fine. The third time could be imprisonment. Or it could be first time fine. The second time, if you're still incorrigible, then you could be imprisonment. No? So it could be part of a sentencing guidelines similar to what I just described, to prevent, quote unquote, the pseudo-journalists, which admittedly is in our presence, especially the type who are what we call the phenomenon of block timers in the Philippines. No? You buy a channel block time, radio radio or video, then you use that to attack and collect. No? That's also a problem that we have to address to preserve the peace in our country. That there's also a reality of bad people like that.
Well, I'll ask Marites what she thinks. Based
Can
on
I add to that?
Oh, of course, Justice Carpio.
In case we go to decriminalize libel and allow only fines, the aggrieved person, the person liable, can recover damages, moral damages, and this could be huge. I mean, many newspapers in UK have suffered financial difficulties because of the huge amounts of damages that were imposed on them for libel, for civil libel. So, I mean, even if you're rich, you may not be able to afford it because the damages could be huge. Thank you.
Okay, thank you. From the journalist's point of view then, Marites, how do the problematic loopholes on the statutes of traditional and cyber libel affect your editorial process? What steps do you take to libel-proof your publication, seeing as there are multiple angles of libel to take into account now with the new reality?
Actually, the old rules say print or online is still very basic about at least 2 sources for the information that you publish, because you always have to check the information. So, and also, you know, there's a lot also of responsibility to be held by the publishers and editors. You know, here it's, I saw a related question. I can maybe talk about it also, about we are a self-regulated industry, and there's been some push from others to say that we should be licensed, but we've always opposed this because we feel that this is like a press freedom issue. So the responsibility really, a lot of it lies with publishers and editors to police their own ranks. The newsrooms are the core of a news operation, and that's where the publishers and editors should set very strict guidelines. Any whiff of or rumor of impropriety, of corruption, that should be dealt with immediately. That's why, well, at least I can speak for when I was editor-in-chief of Newsbreak, we were very strict about it. And I think you have to start the journalists young, the training start while they're still, start them young while they're.
Also, Marites, I'm wondering why in the Philippines, a lot of our major news organizations has not adopted the practice of having a general counsel on board. In most jurisdictions, especially if you're a major outfit, you would have a general counsel. Not for anything. This general counsel, of course, will be the first believer in free speech, no? But I'm sure there's 100 ways to write an article to make it not libelous in the first place. Or if you're reading in that area where your sources are there but do not want to be identified, or you're citing another newspaper source or intelligence report, there are quote-unquote very practical, doable, legal, sensible actions that will actually increase your legal protection to a general counsel board or similar quote-unquote mechanisms that are freely available.
We show sensitive, if we consider articles sensitive, we show them to a lawyer. We don't call them like they're not full-time, they're not in-house necessarily, but we show them to lawyers that we trust and they give us legal advice. Except sometimes, of course, we don't want to use the word allegedly 10 times in an article. So, I mean, when I showed my book on the Supreme Court to a lawyer who went over it before publication, he asked me to put allegedly in so many parts of the book. So when I said, you know, nobody's going to read this, it's always there. So there's a way, as you said, you know, of telling the story without having to be bogged down by legalese. But yes, we do that. We just don't call them general counsel, but we do have lawyers we consult whenever the articles are sensitive.
And this reminds me of a common discussion. No? When your child is sick, you go to a pedia. When you have eyesight, you go to opto and opta and all the subspecialties. But if a legal issue, you just go to a lawyer. You know, and there's no conception of this person as a some background on the working on libel, the history, tradition of particular provisions. You go to a 60-year-old lawyer for a cybercrime case, that's a recipe for disaster, no? If you go to a 25-year-old lawyer for a political case, that's also a recipe for disaster. So we haven't gotten there in terms of understanding the job specific requirement. If you want to learn piano, you just don't go to a music teacher. You go to a piano teacher. You know, just because you're a music teacher doesn't mean you can teach all instruments. And that is exactly where one of the issues on free speech and libel can actually be improved. The general increase of quote unquote the appreciation of how free speech can actually be inculcated legally, responsibly, given that we have an existing criminal regime that still criminalizes libel.
Justice Carpio, you want to add to that, or? Would you like to add to that, Marites or Justice Carpio? Would you have anything to say?
Nothing.
Okay, then I'll move to the next question, which actually is related to what Attorney Sy just said. Is how do you prove beyond reasonable doubt in libel as a guide, as a guideline for criminal libel? At what point is it beyond the reasonable doubt that something libelous was intended?
That really is what you call a judicial rule. No, the proof beyond reasonable doubt has a separate legal history that even precedes libel, which we will not get into. But in the relation of a libel case, you still have to proof beyond reasonable doubt of the elements of libel. There's no question on that. What is easier for the quote unquote the respondent, the defense, is if it's easier for you to prove your defenses. For example, if you have an exempting circumstance or a justifying circumstance, if you make it easier to prove, then the proof of the accused will not be as strong to reach reasonable doubt. That is how you should appreciate the tension. There's no change in the proof beyond reasonable doubt requirement in any criminal litigation, including libel or cyber libel. The same high standard. What we want to see is you make it easier for the journalist, for the person defending the suit, to actually say, no, it is not because this. Hence, the proof beyond reasonable doubt that the complainant wants to establish will actually go down and not meet the proof beyond reasonable doubt requirement. But if your standard of proof for the defense is as high or even higher than proof beyond reasonable doubt, then why bother putting up your defense in the first place? There's no point anymore, because the proof that you need to do, the burden of the truth, is so high that it actually furnishes proof against yourself. That is a practical impact of the burden of proof versus the burden of truth on the part of the respondent.
Sorry. In response to that, if we're talking about the trial itself and the burden of proof, would the defendant be able to invoke as a defense that he sought the advice of counsel before publishing? For example, in your case, Marites, does that work as a defense? That if your counsel said you could publish it, that it was not, potentially libelous?
Unfortunately not, especially if your lawyer does not have a specialty in criminal law. You're setting up yourself for a libel case.
Okay, now this is another question for Marites. In the case of Maria Ressa, there was a discussion about how there was no proof presented about the intelligence report linking Harvey Keng to drug trafficking. From an editor journalist point of view, when facing a libel case, should you shield your source from judicial scrutiny? I think this is also a question for Justice Carpio and Attorney Sy after Marites answers.
Actually, yes, we're not supposed to reveal sources who want to remain confidential. But again, if this story when this happened, we have to corroborate the information from another source. Now through all the years, we've learned lessons that it's always best to corroborate and with a source who is willing to be identified. So we try as much as possible to avoid anonymous sources. It can get very, and yes, we keep our notes. I remember that during my libel hearings that I had to look at my notes. As you said, Attorney C, you know, the burden, but I don't know, because it was public. I'm sorry, it was a private person rather who filed the libel case. So I had to prove that what I wrote was true. Yeah, Justice Carpio wanted to add something.
Yeah, okay. I think the Rappler article quoted an intelligence report, and there is a rule that if you quote a report of a government report without any comment, that's okay. I mean, you're just quoting from a government report. But for me, the case doesn't even have to go that far, because my view is that has the crime, even assuming it has been committed, has it prescribed? So I just discuss prescription, because all of this will be immaterial if the crime has already prescribed. And it's very clear the prescriptive period is only 1 year. And that should have been sufficient to dismiss the case. That is my position.
Attorney C, do you have anything to add about sources?
I think on the discussion of the Rappler case, it's very important that we try to read the article against Justice Corona and King in a very objective manner. And when I first read the article and reread it recently in the decision, the way it was written leaves a lot of room for improvement, if I may say so. The way the article led with the quote-unquote controversies, the way it laid out the quote-unquote the tendency to use other people's cars, the way it laid out, I think should have been written in a very tight mode. The intelligence report, if that was the only problem with the article, would have been an easy defense. But it's the whole series of the way it was written that to the mind of the private person, aside in decision King, was libelous to him. So I think the best is to refer to that particular publication and read it in its entirety, just to be at least make it an educational part for both journalists and lawyers. And I also want to clarify, apologies if when I said 60-year-old or when I said older lawyer, I don't mean any derogatory aspect. I just meant that for somebody who's not technologically savvy, you don't want them to handle technology cases on your behalf. In the same way that if you are a young lawyer, you don't want them to handle politically, constitutionally heavy cases, because experience and command of jurisprudence is essential, which may not be readily available to a younger lawyer versus a senior lawyer.
Okay, now we have a question from Caroline Lee. What part of the law helps to protect people from those who have the resources to indiscriminately accuse another of libel, especially those who have not the resources to defend him or herself?
Unfortunately, Ms. Lee, that's not in the law. The law only provides you the old narrow rules of defense that's allowed in the revised penal code. There's no safe harbor provision. There are no additional safeguards against the respondent. That is the present situation that we have now.
Okay, we have some other questions. We still have quite a few questions to get through. This is from Leslie Lapas to panelists. Can you say that this is politically a double-blade sword, a double-edged sword? Will this somehow undermine the intensity and prevalence of trolls? because I would imagine, yeah, a lot of the cyber libel, I mean, a lot of the, the comments that come out are from troll farms or, so very kind of dangerous, a lot of menacing, a lot of threats and menacing comments as well. So how do you guard against that?
Yes, that's true. It's a double-edged sword. That's why if you are malicious in your intent, you actually don't need to fear the libel laws. You can always hide under the cloak of anonymity, employ a troll farm outside the country. There's 101 ways to libel a person without being connected to it. No? So in a way, no matter how bad libel is, for a person who is malintent, then there's actually no protection afforded to the innocent party. But on the other hand, if the conventions of libel and cyber libel in place, the person whose free speech is actually being challenged on the grounds of libel, kawawa nga in the present regime.
Would you like to add anything to that, Justice Carpio?
Nothing to add.
But you were saying earlier about Facebook could theoretically be sued here, right, for libel, if somebody wanted to do that. Do they have any other protections? I mean, so at the moment, if you comment anonymously on a Facebook post, you're still somehow protected as long as nobody goes after Facebook, as long as are, in the country.
Well, in the Philippines, Facebook has the same status as a newspaper. It's a platform, and they will be treated as a publisher. And if they allow a libelous article to be published in their platform, the Facebook itself will be liable. In the States, they have a safe harbor. They are freed from that liability, but not here. Very few people know this, but a lot of people make comments on Facebook that could be libelous, but it has not been tested yet.
Mm-hmm.
If I may add, for the Facebook issue, this is where the discussion on takedown, the takedown of particular provisions can be situated. If, for example, in the case of very clear problems of child pornography, if you are the provider of the platform, you see child porn, you have to act to prevent its being posted in your site. And if as soon as you see it, and this has extended to hate speech, racism, and similar problematic social imputations, you have the duty to act to clean your platform to prevent it from it being there. But libel is precisely tricky because the border between libel and free speech is actually very, very gray, more than 50 shades of gray. And if you are the particular platform provider, Facebook, when is that libelous or not is usually a judicial determination. You don't want to be there because it becomes, you're now acting like a court, a judge, no? Because a person says it's libelous, take it down. The other person says it's my free speech, don't. No? And that this discussion is in a state of flux. No? And it's good if we, quote unquote, have some parameters and guidelines. But it's very clear. So Facebook has responsibility in very clear speech that is not protected. Child pornography, hate speech, and threats, clear threats on life and liberty are very clearly actionable on the part of the social media platform provider.
I think it just seemed that
Ina?
yes.
Yeah. Look, this is just to let the viewers know that Facebook has partners in the Philippines, Rappler and Vera Files, which do fact checking. So based on the fact checking, rigorous fact checking of these organizations with Facebook, Facebook was able to take down, if you remember, so many post accounts. I don't remember the number, but this is an effort here in the Philippines to clean up the platform of fake news. But it's really tedious. It requires a lot of work, and but at least they have responded in the case of the Philippines.
The nearest analogy that I can think of, Marites, is the problem of graffiti. No, it is a very bad form of graffiti, especially if these are done by an organized group. No, you just keep on spray painting, put up all this, and you just have to keep on cleaning the walls, find out where they are. No? So it's, of course, it's much worse than graffiti, but it's the same social phenomenon that the state and well-meaning citizens are trying to look for solutions to.
On Facebook, you can open an account using a fictitious name, and you can say anything you want there, libeling anyone you want to libel. And what can the libeled person do? He cannot find you. So that libeled person will have to go after Facebook for allowing this platform to be used to libel him. And I think that has not been tested, and maybe one day that can be tested, because I think it's wrong for a platform to just allow anybody to use the platform and attack somebody. The least that the platform can do, that Facebook can do, is to verify the identity of that person, so that if he says something libelous, at least the person libeled can go after that person. Right now, that libeled person cannot even go after the person who libeled him, because that person who libeled him is anonymous. So I think it's only fair that Facebook must require those who open accounts with them to show their real identity. Submit a driver's license or a voter's ID or a student ID, so that at least the person who is libeled can go after this the person who libeled him. I think it's very unfair to the person libeled when he does not know the person who is libeling him. Thank you.
And this is the same problem, Justice Carpio, in the requirement of registration of prepaid SIM cards in the Philippines. In the Philippines, we have the freest regime in the world. For 20 pesos, you can actually get a prepaid card and use it to extort money, to try to fish. You try to use that for kidnapping. You try to use that for all. You see a lot of problems in Pogo using prepaid SIM cards. They can just walk in, buy it in the hundreds, and the telcos are not doing anything about it, simply because it drives revenue growth. In all other countries that you go to, Singapore, Hong Kong, even in Western countries, the SIM is a matter of registration. You have to at least show a passport, sign up with a photo ID for you to be issued a SIM card. No? So that again is where we are in our maturity of security processes. No? And again, people will say my right to communication is curtailed because you're requiring me to register my SIM card. So it's the same form of problem that we are facing.
But also, I mean, this is also looking at it from one, maybe a legal perspective, but also from the perspective of an ordinary citizen. You also want to protect your right to dissent. So, you know, hiding, I suppose, because of the times that we live in at the moment, with the terror law looming and all that, people want to protect themselves from being picked up, you know, in the middle of the night, or warrantless arrests and all that. So there's a certain level of comfort that an anonymous account also gives you that you can't trace. But the matter is there. It's like the important thing is the balance, because there's some that use it for libelous, again, for libelous or malicious reasons, and there's some that use it to protect their constitutional rights. So how do we judge which is which, right? And who's liable for what?
And for a lot of people, it's not only important that it's said. It's important that people know you're the one who's saying it. And if you require anonymity for you to say it, that's exactly what the evil that Bill of Rights is trying to protect. You have the right to say it, and it has to be known that you're the one saying it. There's no need to hide under a cloak or to try to anonymize your statement just to make sure that you can say what you want to state that defines you as a person. So I think that's also what we need to throw into the discussion.
So, well, as a follow-up to this, I guess you just answered it. Is there a right to anonymity on the internet in the Philippines? This question is in defense and advocacy of private citizens in increasingly growing surveillance society.
Yes, there's no legal right to be anonymous, no. But if you remember, all these discussions of libel did not take in the context the rise of the right of privacy, which is a very specific 20th century phenomenon. Before, we didn't have this conception of right to privacy. In the Philippines, our Data Privacy Act is a 2012 conception. Before that, the earliest case, 1960, Morphe versus Mutuk, was our first privacy case. We don't have this idea of privacy until now. So if you talk about anonymity, it's an extension of your right to stay private. You don't want to be traced, you don't want to be known, you want to say things. But of course, it's not as if you can do libelous statements anonymously. You have to live up also with the consequence of being anonymous. Being private doesn't allow you to commit crimes against another person. But I would like to appreciate this right to anonymity in the context of the rise of the right of privacy for individuals.
But it also becomes a little bit delicate when the person judging you to be saying something libelous is actually like a public figure or something who has every right to be criticized. So
Correct.
it's a form of self-protection for citizens, right? I mean, if being open about your dissent is actually going to land you with, a warrantless arrest in jail for how long is it now? 24 days. You can be held for 24 days without charges according to the terror law. I might be wrong, you can correct me, but it's actually citizens trying to find ways to protect themselves.
Correct.
With the engine of the law.
That's why in my earlier introduction, Ms. Bambina, I talked about the new normal, because the new normal is just not for pandemic purposes. The new normal for libel, for social media, for technology law requires a different thinking. Once you post an article, it's going to be there forever. Is it a continuous publication? Once it's posted, always there in any of the millions of servers in the world. So those are the new normal perspectives on law that we haven't addressed. We're still at that old classical conception of huli ka, masama ka, arestado ka, kulong ka. That we're still in that discussion of a very classical testament type of talion law, an eye for an eye type of punishment.
I'd like to add, the structure of our freedom of expression is this. If you speak against the government or the president, congressman, and so on, and you are charged with sedition, the bar is very high for you to be convicted. And that gives you comfort that you can say it publicly. You can come out openly because the bar is very high. And also, if you libel a public figure, the bar is very high also because it's the public figure who must prove actual malice. There is no presumption of actual malice. So that's the trade-off. You cannot hide, you cannot use another identity to make those speeches to attack people because you are already given a very exalted position. It's very, the bar to convict you is very high. So you should not be afraid to come out openly. That's the trade-off. Thank you.
I think we should start closing now, wrapping this up. I think we have one question from one of our from the audience, and I think it might be a great question to think about as we wrap up. It will apply to everyone. How do you keep your morale and belief in the precision and objectivity of the law alive in the midst of blatant exploitation of the law for political ends? In other words, how do you keep motivated to fight for our laws? And in Marites' case, for press freedom. Who would like to go first?
Marites.
Well, I've always been saying that the times have really changed. I mean, this is an administration that has broken the rule of law, weakened our institutions. In fact, Justice Carpio, the bar is very high, but I don't have confidence to go to the Supreme Court. I mean, honestly, because of the way they voted recently, and of course, it's this justices concept of utang na loob to the appointing power. As you've said before, Justice Carp's independence is very important. So I lack many lack the confidence in going to the Supreme Court, even if the bar has been set very high. But still, it's good to test. It's just a very difficult time we're in. So we have to continue doing our work as journalists, and as long as we follow, of course, the rules, and we're very observant of basic tenets of journalism. So we just keep doing our work. That's all.
Thanks, Marites. Attorney Sy or Justice Carpio?
I will defer to Justice Carpio.
Well, I think you have to, many of us who have been through martial law, and now we are in this period, have a better view that, this will not continue. There will be an end to this, and we just have to stay the course. And this is part of the evolution of the law. All these questions now before the Supreme Court on the anti-terror law, this libel case of Rappler, will eventually improve our law. And that's part of the development of the law. But the players must continue doing what they have to do so that we develop a better legal system. But this is, if you've been through martial law, this is, you know that this will come to pass also. So you don't have to be discouraged that much. Thank you.
Fortunately and unfortunately, I was a post-martial law baby. So this is my first experience of similar matter. But having served in government for almost 20 years, I share the sentiment that there's always the general goodness, except that sometimes goodness you have to keep at working at the good, whereas the bad always takes its natural course. You have to keep at it, and that's the only way you go through life, whether it's as a journalist or as an educator, as a lawyer, and especially as a public servant. You just have to keep at it.
Thank you so much to all our panelists for joining us today. That was a really, really illuminating talk about the law and libel, and obviously it affects a lot of other things, especially in the times we live in at the moment. I guess we have, as citizens, we just need to fight, and fight a good fight, I guess, like as the late John Lewis said, get into trouble, but get into good trouble for the right cause. Thank you again, Academiang Filipino, for organizing this with us. We look forward to working together on future webinars for you. We have coming up in August 4 another interesting webinar on the anti-terror law and its implications for all of us, whether it's upheld by the Supreme Court or not, right? Because there are 6 petitions in front of the Supreme Court at the moment. And that will be on August 4 from 5 p.m. With Attorney Chel Diokno joining us. So please join us for that as well. And thank you once more to all our attendees, our many members who joined us today. A recording of this will be posted on YouTube on the Manila House channel in the next couple of days. So thank you very much. And if you'd like a recording, personal recording, please just get in touch with me and let me know. We hope to have the pleasure of having our panelists again in another webinar. And have a good evening, everybody, and thank you. Thanks for joining us.
Thank you.
Bye-bye.
Bye-bye.